we'll talk about the mess caused by biohazards, both in the home and in coverage. Hi, I'm Gary Reinhardt and welcome to CoverageCast. This is our look at what's trending in the insurance industry and what will be coming across your desk in the next few months. Today we want to talk about the unfortunate circumstance where either a violent act occurs in a home or a business, or someone passes away and goes undiscovered, and other biohazards. Cleanup for these type of things is costly and specialized. It also can create coverage issues. In some contexts, we have to first start, of course, with an occurrence. In a violent act perpetrated by an insured, it would probably not be covered, either as an intentional act or not even an occurrence. If the insured is the victim or the unfortunate possibility that someone dies, then you have an occurrence and you have a coverage issue. In the case of a shooting, some people have tried to find coverage through saying that it's an explosion, as the discharge of a bullet requires an explosive force. The response to that at times, however, has been to assert the absolute pollution exclusion. A pollutant has been defined in the policies as any solid, liquid, gaseous, or thermal irritant or contaminant. This absolute pollution exclusion has resulted in a lot of litigation. One of the issues that arises is what is a pollutant despite this broad definition. Some courts have taken to calling only things that are created through the manufacturing process and not naturally occurring as a pollutant. The argument for this interpretation is otherwise the all-encompassing pollution exclusion would render the policy essentially meaningless. Even a water backup could be seen as pollution if it causes contamination or irritation. However, others enforce it as it's written, and any substance that is where it's not supposed to be, that causes contamination or irritation, is subject to the absolute pollution exclusion. Two cases, one out of Florida and one out of Pennsylvania, recently held that biohazards, bodily fluids leaving from dead bodies, was indeed pollution, and they excluded coverage. However, something to keep in mind is the lien holder clause. A lot of lien holder clauses now protect the mortgagee in almost every circumstance, as long as what occurs is the result of an act or neglect of the insured. In the case of the insured as perpetrator, the lien holder would still be protected and covered for these biohazards. So keep that in mind when a claim is presented and you have one of these unfortunate circumstances that occurs on your insured premises. If you have questions about this or any other matter, please give us a call at Callball Fund and Messersmith. We are one firm, your firm.